welcome to Legally Speaking with me, Tarun Nagia. Today, we're going to discuss a very important judgment, which is called the Tiger Global Judgment. Why is this important? Because it lays down certain important milestones in India's evolving tax jurisprudence. And that is what we are going to reflect on today. I want to welcome Senior Advocate Percival Bilemoria, Advocate Namisha Gupta, Advocate Siddharth Sharma, who practices as a senior standing counsel for the Income Tax Department, and he's also a senior standing counsel from the GST and the Central Excise. So I think we get a bit of prosecution view as well, having him on the panel. Good to see all of you, and thank you for your time. At the outset, I'll go to Senior Advocate Percival Bilemoria for his opening comment on the Tiger Global Judgment.
Thanks, Tarun. Thank you for having me. So this raises very old memories because, you remember a tax treaty has always been a very, very debatable issue. And I think there was a particular jurisprudence that was established. What Tiger Global decision now does is overturns a large part of that jurisprudence, which is why you will find a lot of people standing up and objecting to that. One of the things that I must tell you is that Justice Pardiwala in this decision talks at some length on, taxation as a sovereign right. All right, and I think that commentary is worth looking at. See, for a very long time, tax treaties were meant to avoid double taxation. So if you are a cross-border player, a multinational typically, you will pay tax in your home country as well as in the country in which you're invested or are doing business. And Indian taxation is source-based. If the source of income is in India, it should be taxed. That's the general Indian rule. So tax treaties prevented double taxation. It provides a mechanism for tax credit in that case in the home country. And sometime in the early 1990s, when we had shipped most of our gold to the Bank of England, right? There was a huge crisis. In the Indian economy, and we negotiated the commodity. Intention is that, well, it was something that was negotiated, and now how can we go back on that? What it said, what that Mauritius Treaty essentially said is that if you are a tax resident of Mauritius and you invest in India, any capital gains that accrue to you, even though the source of those gains may be in India, the capital gain will be exempt. So, the issue is that, look, at that time, as a sovereign nation, you thought it fit to negotiate this because that was a period in our history when we required, it was an incentive for people to invest. So it was a special benefit that was granted. And how can you now take it away? Now, now what does this judgment say, which I think directly counters this? So it says a couple of things. It says that a tax residency certificate, because after a lot of litigation, it came around to saying that, okay, if you have a tax residency certificate, that is adequate evidence. There was a circular that was issued by the tax department. Now this judgment says that tax residency certificate alone would not be sufficient to take benefit of the treaty. It also says that the circular cannot deal with law that evolves. So the circular that is issued, Circular 789, is pertinent only to the prevailing law at that point of time. After that, the law has evolved, things have changed, so you cannot invoke that. And the more worrying factor to investors and tax advisors is the ruling that the Indian anti-avoidance rules, what we call as GAAR, GAAR, General Anti-Avoidance Rule, which are in the domestic law, can be invoked to test residents. And moreover, these rules came into force sometime, I think, from April 1, 2017. And it also says that it can be invoked for investment that took place prior to. So, the whole landscape has changed, and it's, more goes to the mill. But I do recommend that the naysayers should really read, what Justice Partiwala has to say about, you know, sovereignty in taxation.
Point very well taken. Thank you for that opening comment. I'll go to Advocate Namisha Gupta for her opening comment on the Tiger Global judgment.
Uh, Tarun, what I really feel is that I agree with what Sir has said, that sovereignty, one must one must understand what the Supreme Court has tried to establish here, but one must also at the same time understand that the law has not been changed here. There is no new law that has been established by the Supreme Court. The Parliament had already enacted this legislation, and the Supreme Court has merely enforced it. Uh, and while the concerns of the investors may be very legitimate here, in terms of, because the predictability may have been lost in terms of these tax residency certificates that these multinational companies have been holding, and now the general anti-avoidance rules come in and say that they can override these treaties, so that predictability of investment, predictability of functioning has been lost. uh, but this is already a legislative effect, and it is not something that the Supreme Court today has overturned with this judgment.
I'll go to Advocate Siddharth Sharma for his comment. Thank you, Namisha, for your opening comment.
So, my opening comment is that this case is being read in a very large perspective as what effect it will have on all the international investments, etc. But what is skipping the discussion is that it has to be seen on a case to case basis. The minuteness and the details of the whole transaction has to be seen. Now, when you look at the specific case at hand, the facts and circumstances of this case, it's clear that this was an entity that was clearly established for tax avoidance. And the provision in law is already there, just like Ms. Namisha has pointed it out under 245R subclause 2. The word prima facie design is there for the avoidance of tax. So, in this case, the effect control over significant transactions was based outside Mauritius. And this was a device that was clearly used to evade tax. So, while international investments are encouraged, this is a case that has boosted the morale of the department, because anything that goes against the intent of law, it's the intent of law is to encourage investment. Intent of law is not to make devices to abuse the law, as has been happening in this case. So my opening comment is that law is there to encourage investments, but it is not there for abuse, that you make devices specially to avoid taxes, entity having nothing in Mauritius, but suddenly one day it comes into existence just to be used as a tax saving device. So, what my opening comment is that this has to be read in the facts and circumstances of this case, and not like a general rule that discourages investments across the board.
Point very well taken. Now I'll go to some questions that will force us to think what this judgment is really getting us to. Uh, First would be that, is this ruling strengthening India's fight against treaty abuse, or is it created more uncertainty for the global investor or the genuine investor? Let me put it that way. Has it created more uncertainty for the genuine investor, or it has sort of strengthened India's stance? Secondly, are courts moving towards a substance over form doctrine that could make investment structures unpredictable? I mean, you design an India specific investment structure to invest in this country, And if a ruling of this kind comes, then does India get the tag of an unpredictable market? I would request Senior Advocate Percival Bilimoria to reflect, and also if you could also on this reflect that will global private equity and VC funds rethink routing funds investments through treaty jurisdictions like Singapore and Mauritius, uh, maybe presuming that there could be, despite the structure being perfectly legitimate, the court order could be adverse.
Yeah, so look, one of the main criticism that I might tend to agree with is that investment in India needs certainty. You can't spring a surprise on anyone. And you will recall Vodafone, it was a similar, very different, but a similar dispute. And I remember, sitting in New York on the balcony, having my breakfast, and I opened the newspaper, which fell into my eggs because our finance minister, Mr. Pranab Mukherjee, had just made a statement saying that, well, if India taxes foreign investment, we are not going to eat lizards. So that was a funny and yet a very, very stunning kind of statement made in Parliament at that time. So certainty is the yardstick of any foreign investor. If you keep chopping and changing rules, then you do not attract foreign investment. And I think again, I'm saying that please read, the judgment of Justice Partiwala because it provides a very different perspective. I mean, the main judgment has been written by Justice Mahadevan, but Justice Partiwala's part is what I find very intriguing and which should answer your question is as far as form over substance is concerned, that's always been the rule, right from the time of McDowell's case, which tried to distinguish between tax avoidance and tax planning. What it said is that, look, every taxpayer is entitled to arrange its affairs in a manner that you pay the minimum tax. So that was also the Supreme Court and very good, oft-quoted decision, over the years. And I don't believe that this judgment changes that, which is why, what Siddharth says is very important, which is that you have to look at this, whether this will kind of revamp the entire law and how tax treaties are treated by revenue authorities. I would say that there are certain particular, very peculiar facts of the case over here, which so you have to read this judgment in line with those facts. And I don't believe that it can be capable of universal application as a thumb rule. But what it will certainly do is it will have, it will encourage more litigation of this sort.
Point very well taken. Your second last statement, which you said that it doesn't have a universal application, maybe case specific. I'll go to Advocate Namisha Gupta for a comments on the questions that I asked you. Plus, also I want to ask you one more question, Namisha. Is that uh, will India be seen as a litigation heavy country despite reforms? Because I put a certain structure in place, even if to avoid taxes, but perfectly legitimate. Because using Mauritius or Singapore as a route is also legitimate in a way because the laws allow for that. But then if the court rulings are adverse, would the risk premium on India be more? Because you never know that there may be a case later and you may have to pay taxes.
Tarun, yes, of course, litigation may increase, as Sir has rightly pointed out. But what India has done is not really different from what India is not acting in isolation. Around the world, there are jurisdictions that are tightening these anti-treaty shopping norms. Uh, so the days of purely conduit entities with minimal substances are fading globally. It's not something that is happening in India. So while yes, it may look like initially that litigation may increase and this may be discouraging for the investors, but it's actually in India is in sync with the rest of the world. Uh, if we see that the judgment nowhere says that the treaty benefits are invalid. It is only saying that treaty benefits are conditional upon genuine commercial substance, which is inconsistent with global standards, including the OECD anti-abuse principles or the BEPS recommendations. So nowhere I feel that India has done something which is not in line or not in sync with the rest of the world. And it's just draw India with this judgment, I feel it just draws a line between the legitimate tax efficiency and the impermissible avoidance agreements. So this, I think it's very important for us to understand the distinction between the legitimate tax efficiency and the impermissible avoidance arrangements here. And which is where the facts of this case become very, very important. And it should not be seen as a general rule that has been laid down to discourage investment or viewed. And in fact, I remember that there was a comment from the CBDT which clarified that the past cases would not be reopened automatically. So it's not like that the tax department or the system or the government here is looking to just increase litigation. And of course, we want investments, but the court is just reinforcing, like Sir said, the sovereignty of the Indian tax base. When a substantial value is generated in India through Indian assets and in the Indian markets, the state is entitled to examine whether that value should bear Indian tax or not.
Point well taken. I'll go to Advocate Siddharth Sharma for his comment.
See, first of all, genuine investors will always be interested. And in fact, when genuine investors are highlighted, it is only because of cases like this. Because here we are dealing with the situation wherein a device was made only with the intent to abuse this agreement. Now, there were significant findings about effect, control over the transactions. There were also findings about the absence of commercial substance in Mauritius. So, when these things come into the picture, there may be genuine investors in those countries that were earlier being left out because of the presence of these kind of non genuine people. So, like Mr. Percival also said, this has to be only seen in the facts and circumstances of this instant case. The law is already there, the agreements are already there to provide for the incentives. So, in no way degrades India's status as a attractive investment hub, and especially to take advantage of such treaties. This judgment has to be strictly seen in the facts and circumstances of this case, wherein there was an entity designed to avoid taxes. This was not a case where you can say that this was for the purpose of attracting foreign investment all over the world, and suddenly a judgment comes and it discourages the foreign investment. This is a case wherein an entity was designed only to avoid taxes and it was caught by the relevant mechanism. So that's all my comment is. And
I take your point well, Siddharth.
Sorry, I just forgot. As far as the litigation is concerned, the government always comes up with many policies to reduce it as much as possible. There was a Vivad Se Vishwas scheme also recently that clearly shows the intent of government in reducing litigation as much as possible in various courts of law. So from time to time, these circular come, fraud, compounding, etc. And even the new act is simplified as compared to the old act in this regard.
Point very well taken, Siddharth. I'll take this to Senior Advocate Percival Bilimoria. One thing that I want you to reflect on is that structuring to avoid taxes is a perfect legitimate activity, or it has shades where the court may want to look at it. Many times we are told that structuring is something that all corporates do all over the world. I mean, it happens in America, it happens in every country that many of these companies are headquartered elsewhere. So structuring for tax avoidance is a legitimate activity as far as what I have been hearing. Could you reflect on this aspect and then on the Tiger Global judgment?
Yeah, so that what you just said, Tarun, is the rule set out in McDowell's. that you can arrange your affairs in a manner where you can pay the least amount of tax. You have a right to do so. But I think, look, frankly, if I were to look at this, I think, this also has limits. And I think the era where, accountants and lawyers sat in conference rooms and moved around little boxes, right? What the term used was that we cannot just be a post box company. So, for example, as a foreign investor, if you're coming to India, right, and your country also has a tax treaty with India, but you route your investment through Singapore or Mauritius because that treaty is more favorable and it affords you exemption from income that you expect to earn in the near future. It may be license fee, royalty, in this case, capital gains tax, which is the most common. Then you set up a what we call as a post box company. A company has no substance; it's just a post box. I think that's taking it to a extreme level, and which is why I'm again saying that I think this is exactly what Justice Partiwala means in his tax sovereignty discussion. So to answer your question, I think the days of post box companies are now well and truly over, which is just as well. And I think somebody pointed out that this has happened in other jurisdictions. For example, in UK, you have a similar debate that is going on, and also in US, US also tax world income, right? So I think these are debates that are now coming up. We do have a very robust OECD rules structure that look at tax treaties and set out thumb rules, right? And I think those are fairly untouched here by this decision. What it does say is that you can import your anti-avoidance rules into domestic law to look at whether you are tax resident or not. So the rule was that if you have a certificate, a tax residency certificate, that's it. Let's not go into too much debate. I think this is the one big change that has been brought about by this judgment.
Point very well taken. Uh, Again, the issue of structuring doesn't end here because world over companies use structuring ostensibly to avoid taxes, but it's not violating any law. Nanisha, Advocate Nanisha, would you like to weigh on this a little bit?
Uh, Tarun, the way I'm able to look at it is that it's actually, I think that this is just about maturing a tax regime which is already in place. So I feel that it's while it's protecting the sovereign revenue, it's also protecting the investor's certainty. So I feel that the court has titled the scale slightly towards revenue protection, but within a statutory framework, it's enacted, which has already been enacted by the parliament, like I mentioned earlier, and aligned with international anti-abuse norms. So I feel that the true test will now lie in implementation, how tax authorities choose to apply the general anti-avoidance rules carefully and proportionately with clear reasoning, and the judgment definitely, in if applied carefully and proportionately, will strengthen India's credibility
Point,
as a
point,
credible market.
point well taken. I think we need to see and wait for a few more days for reactions on this judgment, which will come from global corporates. We heard Siddharth, who gave his view, and Advocate Tamisha Gupta, Senior Advocate Percival Billimoria, who gave a rounded view. We need to maybe discuss this more after a couple of months, given that, in the market where every country wants investment, there are things you look for, and there are things that you look over. Uh, uh, you know, uh, there is economic impact for whatever decision you take. Given that as an aspect, uh, I want to see how this judgment is seen 6 months or a year from now. and then maybe sort of take it up again in retrospect, because I think that will provide some perspective on the issue much more than today. But I would like to thank Senior Advocate Percival Bilimoria, Advocate Namisha Gupta, Advocate Siddharth Sharma for joining on this very important topic in judgment, and viewers for tuning in. Thank you so very much.
Thank you so much, Tarun.
Thank you. Thank you, Dharma.